Good afternoon. Today we will be holding an online seminar entitled Oregon Elder and Child Abuse Reporting, and we'll be talking about the concerns, the requirements, and some general themes regarding what lawyers are expected and obligated to do in Oregon and around the country about issues of elder and child abuse reporting arising in their practice. My name is Jordy Duckler. I'll be your presenter today. Just so you know, I have been a trial attorney for over 34 years. My licenses are in Oregon and California. I have been actively engaged in both the plaintiff and defense side of civil and criminal litigation in cases of all types across the country in both the state and federal courts. I have considered this specific topic in great detail throughout my career. I presented several different seminars on it, and today I hope to get you well informed and up to speed about all that you need to know in this very interesting area of law. We will focus on Oregon law in this area, but we will also compare rules and cases in other states as well to get a better handle on where Oregon law fits into the national conversation. First, let's start with child abuse reporting, and let's take an overview of some philosophical themes that apply. We can set the ground rules down about two core concepts which make a difference to why we are concerned about this area at all: ethics and reporting. First, with ethics, in a narrow sense, the seminar is, of course, about the obligations attorneys have regarding reporting abuse of children and of elderly people. But in a much larger sense, however, it is about ethical commands in general and the role that such commands play in society when affecting specialized institutions, such as the legal system. Law, altogether, is a compromise. It's a compromise between moral ideas and practical possibilities, and the same is true of legal ethics. How lawyers reconcile the tension between some moral aspiration they might have and some pragmatic constraint they might have is important not just for the profession, but for the public as well. Lawyers play a crucial role in the structure of our private affairs, our social institutions, and this role carries multiple, sometimes competing responsibilities to clients and courts and society in general. Lawyers also face conflicts between their professional obligations and their own personal interests. A central challenge of legal practice is how to live a life of integrity in that tension between those competing demands, ethics and practice. It's a fact of life that ethical dilemmas are always around to be resolved for lawyers. They never go away. Partly, that's a function of just a lack of consensus in the profession about what the problems are, what values should be central to a professional life. We can at least agree in general that clients deserve reasonable access to legal assistance and to legal processes that satisfy some minimum standard of fairness, effectiveness, and integrity, and that practitioners deserve conditions that identify what the standards are to provide that access. It's in the day-to-day practice of law that we find difficulties arise, and it's where we use compromise to address the confrontation between the theory of moral commitment and the reality of doing law. For us today, the ethics of mandatory reporting highlights that compromise. It draws on insights we might glean about those competing demands. We are going to look at both the narrow and the broad, and we are going to keep in mind the overall theme that any ethical command must create a tension among and within both social and legal relationships, something that lawyers are heavily intricated in. This is necessarily so, given political, sociological, and cultural order of a constitution-based democracy such as ours. So when it comes to ethical commands to attorneys in particular, and the protection of vulnerable people in particular, things such as mandatory child and elder abuse reporting by attorneys highlights a number of concepts involved in identifying those tensions that affect those relationships. We're going to look at three. The first tension involves the subject of the reporting requirement, which is, in this case, the child. This is that tension between our communal interest in protecting the public at large and our narrower interest in protecting certain subdivisions of the public, folks who might need special security measures provided for them, here, minors and clients. And we might need to find that protection taken from others who might take unfair advantage of them. That tension exists because there is no realistic way to both protect everybody as if they were all truly equal, and yet at the same time attach importance to certain inequalities which we can't help but recognize as real.